YouTube, it's Tone. I'm back with another one for you. This one is a continuation of dealing with presentments. This is the 8th video, and this is a good one too. So let's get right into this shit. So this goes into what the public charitable trust is, which is what the administrators of the courts, which they call themselves judges, or maybe they don't, but you call them judges. The administrators or clerks of the court that call themselves judges are administrators for the public charitable trust, which you are a part of, or your straw man is a part of, right? So that is constructive and not express. Constructive means that the trust is constructed, created, manufactured, concocted by operation of law, i.e., out of nothing, as just another of an uncountable number of legal fictions of which the entire system consists of, by the whim and fiat of those who own the particular law form in which the trust is indentured and domiciled. In this case of the United States, the jurisdiction is the private, commercial, international, military jurisdiction of the original incorporation of the U.S. incorporated in 1871. So there hasn't been a real fucking court since then. So within the 14th Amendment and emergency war powers implemented at the advent of the Civil War that suspended law and terminated thereafter operation of de jure government under the original charter in 1787. Now, none of us were there when this shit happened, but I would imagine it was something similar to the bullshit that you see now in the mainstream media. And Civil War is not a fucking actual gun war. It wouldn't be called civil, otherwise it would be called a war, a guerrilla war, Civil War. That shit was paperwork, okay? And keep in mind how grimy the mainstream media is now at this point, and I hope you don't think that they were any less grimy back then to have created this fucking nonsense story that I just read to you. So anyway, moving on. A citizen of the United States was created by within the 14th Amendment as a corporate civilly dead entity operating as a co-trustee of the PCT. The 14th Amendment upholds the debt of the USA and the US Inc. in Section 4 of the amendment, which states that the debt shall not be questioned. That is part of the terms and conditions of your co-trustee position. If you question the debt, you are in violation of your own contractual obligations. Endeavoring to find fault within the system of any of those operating on its behalf is considered as arguing against yourself, which every judge immediately dismisses as self-evident error, if not insanity. No wonder judges are so fond of ordering psychiatric evaluations for those who appear in those courts in these days. Right, but who's checking the mental health of these people? Are they getting their fucking mental health checks? So it is presumed that everyone who states that he is a citizen of the United States Inc. or acts as if he were has knowingly, intentionally, and voluntarily contracted into the private, military, international, commercial, admiralty, equity, law form of the 14th Amendment. PCT surrendered all rights and agreed to be bound by the alleged resulting contract. One is now on the ship where the captain's word is law and trying to protect your rights and find the system in error or walk off the job is walking off the plank. But you could rescind at any point too. Keep that in mind, right? Because everything is contracts. At any point that you feel that these people are not representing your best interests, you can go ahead and put in an affidavit of rescission of all contracts related to anything that has to do with them, the case, etc. Because they are there for your benefit. But even though they act otherwise. Even though all this shit is lessons, ultimately. If you get, you pull your feelings out of this whole situation, it's really all just lessons and shit. But these people are still annoying nonetheless. So in the PCT, every citizen of the United States acts in dual capacity as co-trustee and co-beneficiary. This means that as a citizen, you have on the one hand as a co-trustee obligations and duties, such as the requirement to comply with all the system's codes, rules, regulations, laws, statutes, and public policy, if you're operating in the public, of course, right? And on the other hand, wearing the hat of the co-beneficiary, you can receive benefits such as welfare and other rob Peter to pay Paul style token benefits such as retirement, such as retirement benefits, unemployment insurance, and other trinkets doled out in exchange for having sold your birthright for a bowl of porridge. So there is no grantor or truster, although there is a creator to a PCT because it is an implied trust, i.e. constructed and not formed by express written bilateral contracts, etc. But it is a express contract, and it is written because they all sign up for that when they sign their oath of office to the state constitution. So they do have obligations there. You don't, but they do. Your straw man does, but you don't. You know what I'm saying? So when you understand it like that, you see what it is. So once you are in PCT, you can contract into Social Security, which is a revisionary, revocable trust, and the New Deal, a socialist communist scheme in which all participants are tortfeasors who secure by membership benefits which they are not entitled by having extracted at legal gunpoint from other people. Accepting Social Security or any other government benefits is accepting stolen goods, providing the system with an excuse to consider you guilty until proven innocent. Right? So they give you the rope that you need to hang yourself, and you tie that shit around your neck. You know what I mean? But you don't have to. You can just leave that shit on the floor right there where that shit belongs. So therefore, in any court case, the action is being brought by the alleged offended beneficiary. Right? They're trying to act like the beneficiary in all these situations. You have to understand what's going on in court. They're trying to flip the tables on you to make you the trustee and them the beneficiaries when that's not the case. They are the fucking trustees, which are the slaves. Okay, it's them who signed up to be the public servants, right? And if they don't know what the definition of a servant is, maybe they should look that shit up. But you see how crazy the system is when they can convince all these people who literally signed up to be public servants that somehow servant means fucking king, right? These people literally got it twisted. But you see how much they dumbed everybody down that they could literally convince servants that they somehow have more power than the people that they serve. That shit is crazy. That shit is straight fucking mind control, okay? So this is why the law and facts are completely irrelevant. If you go into court trying to argue either, you must necessarily lose, since the only issue is whether your straw man faithfully performed its duties as trustee of the trust, such as to obey statutes, pay the taxes, or whatever else is required in accordance with the ever-increasing ocean of bylaws of U.S. incorporation. If you raise objections or law or facts, you not only traverse and dishonor by arguing and therefore automatically lose, but you give witness testimony against yourself that you are a bad delinquent trustee trying to escape your duties as a co-trustee of the PCT. So you are thereby presumed guilty. Your fatal error is not the first and foremost that you argued, denied, rebutted, traversed, dishonored, and tried to avoid your contractual and fiduciary obligations of securing, obtaining a driver's license, getting a passport, etc., etc. as co-trustee, but that you have failed to rebut the presumption that you are the co-trustee, i.e. the same name as the defendant strawman citizen. This is why there is only one issue and all the rest is so much irrelevant fraud. The issue is whether or not you rebut the operational presumption. If you do not, nothing else matters. The presumption, where the power and teeth are, stands, and you lose by simply not rebutting the operational presumption, which is one that you are the same as the name that they are naming in that particular courtroom. You're not the defendant. You're the administrator, the same that the judge is not really a judge, but an administrator for the public trust. Okay, so you as the living principle are real and exist on the substantive private side. The straw man, all caps name, defendant, is fictitious and exists only on the imaginary public side. The living principle cannot be seen, addressed, or dealt with by the public side, which is a reflection in the mirror of a chimera. The defendant cannot enter or access the private side, just as the living principle cannot enter the public domain. It is essential to neutralize the presumption by which the system operates against us, which is that the living principle is presumed to be attached to and united with the straw man, so that whatever is done to the straw man is imposed in the flesh on the living principle. It is the unrebutted presumption of the union of the real and fictitious that enables the court to access the real you. This is why it is crucial to neutralize that presumption and render it inoperable by rebutting the presumption initially and presenting your UCC1 filing showing that you are the superior lien holder on that particular ens legis or straw man, fictional character, whatever you want to call it. You're all caps, whatever you want to call it. You must not traverse or dishonor. You cannot win by arguing in let's pretend mirage land. You must end the controversy, i.e. terminate the presumption of the existence of a dispute on both the private and the public sides. The obligation charges must be discharged so that the books balance and you have complied with the law in both domains. The public side is bankrupt, has no capacity to execute a sentence, and cannot charge you in common law. The charges are in the nature of, meaning colorable, civil or criminal charges in common law, meaning that they are in the form only without any of the substance. So this is also among other reasons why you cannot lien public officials. Doing so is a common law substance process, and as a bankrupt entity, they cannot provide you with a remedy. Trying to lien public officials is a dishonor and crime by endeavoring to impose a common law remedy in a sphere that cannot be accessed by common law. No, because you would have to get them to actually agree. So when you get your agreements, when you perform your administrative process on these people and start serving them with your promissory estoppel and all the proof that you already served them, along with your invoices, along with a list of their violations and things like that. When you perform the administrative process and they silently acquiesce to them, then you have an agreement. Therefore, you can go ahead and put a lien on them, and then you can draw from the treasury from their estate the same way that they do from you, right? So you wouldn't have to worry about them actually paying you. You can go ahead and write yourself a mortgage and things like that based on their straw man that you're leaning, and you can go ahead and draw those funds on the private side off of the Treasury Department. You wouldn't even need them to actually pay you anything. The same way that they do it to you when they lean your straw man's name and throw you in jail and all that. They're drawing the funds from the private side, from the Treasury Department, because you agreed and let them put a lien on you. So several possibilities in lieu of or in addition to the three questions approached below for dealing with the same issue come to mind. These statements are intended as satisfying all of the above essential elements. When your straw man's name is called or the judge asks you or for your name, you could say one of the following, whatever you are comfortable with. I am here concerning that matter. Or, I am here as a third-party intervener in that matter appearing as authorized representative for my client, right? I personally would say that I'm here as the authorized representative on behalf of Anthony Figueroa, or the all caps name, or whatever your name would be. Now, mind you, I went ahead and incorporated that whole name too as well. So if I ever have any issues, I'm showing up as the corporate version of myself with my EIN and my invoices and things like that, because I'm going to assume that they want to do business because they are corporations as well. So I personally would go into that assuming that. Right, and throw that shit on the table and see what sticks. And if they want to rebut my presumptions, since they like to assume and presume shit, I'm gonna assume that you want to do business, and I'm gonna go in there accordingly with tax paperwork and things like that, right? And if you want to claim that it's not a commercial public transaction, well, then you can prove otherwise. But I'm gonna assume that this is what the case is because I don't see anything else here. You know what I'm saying? Plus, you show up with all their DUNS numbers, their registered business numbers, and things like that. They're all for-profit corporations pretending to be something else. So it's really that simple. So I am here as a third-party intervener in that matter appearing as authorized representative for my client. The third-party intervener is you, the living principal, acting in your own interest because you have a pre-existing claim against the defendant that precludes them from acting against any version of your all caps name based on your prior contract therewith, such as your UCC, specific power of attorney, and indemnity bond. Indemnity means that you cannot be held liable, or hold harmless agreement, the same thing. Your employee ID, which is your EIN, exemption ID number. And then continue. I accept for value and return for value all of the charging instruments in this matter and make my exemption available, not offer, since we never make offers, for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, because you want to avoid any of the controversy. There isn't even anything to argue with. First of all, these people are not even real. They probably don't even exist in real fucking life. You know what I'm saying? They're just somebody who sits there, goes home, and comes back and sits there. You know what I'm saying? So you're dealing with people like this. This is the type of people that you're dealing with. So let's see here. I accept for value and return for value all of the charging instruments in this matter and make my exemption available, not offer since we never make offers. For discharge of all obligations and charges connected with this case, I do not dispute any of the facts in the charging instruments. Remember that you want to avoid controversy. It's really just a matter. It's a what do you call it? It's really just a civil matter disguised as a criminal matter, which ultimately is going to be commercial in nature. So you want to just deal with it from that aspect, and don't sit here and argue with these people because they're really just a bunch of nobodies trying to get money out of you. So we must remember that problems are not solved on the same level of the problems. We cannot resolve the imaginary dispute in the imaginary domain. We must not try to play with public funds. We must not try to prove ourselves innocent, and we must not plead not guilty, which is arguing, traversing, dishonoring, and telling them that you are joining the imaginary game and treating it as if it was real. All attempts to do these things are traversing and dishonor, breaking the law and committing treason against the equity court by trying to deal with the disputes as if it were substantive, private, real, and in common law. The courts then convict us for contempt of court and impose the common law sentence. So we must also remember that they need us as the living principle to be a witness against ourselves, testify and make the legal determination for them that we are the one they are looking for, and that's looking for in their pretend game and want to prosecute, convict, and punish. They need us to volunteer into contracting with them into their public domain. They cannot make the legal determination that the defendant has anything to do with us. It is up to us to hang ourselves. And I mean, that's what I was just telling you. So they do give you the rope, right? The above statement satisfies all of the essential criteria as follows. The catch-22 of the matter is that under common law, you are presumed innocent until proven guilty, whereas in the Admiralty Equity Court, you are presumed guilty until you can prove yourself innocent, which is impossible in their let's pretend presumption game because you can't prove a negative, all right? So that shit is a trick just from jump. So you're going to sit there and play them stupid-ass games. How the fuck do you plan on proving yourself innocent? You can't. That's not some shit you can. If you can try to prove yourself innocent, you are in dishonor and are charged with a breach of trust to the beneficiary of the state. Also, you're making it seem like they even have this power for you to sit there and pretend to be innocent anyway. Like, who the fuck are you to begin with anyway? You guys are not gods, but you're really pretending to be, right? And that's the only one that could judge me if you believe in a god. So I don't know who the fuck these men are sitting here pretending to be somebody. So by so doing, you commit treason against the court by trying to secure a common law remedy when none is possible. And you do not neutralize the presumption and indeed ratify its force and effect while admitting that you have a delinquent trustee and acted in violation of your fiduciary duty. Now, you can get ahead of any of these points too when you go into court to go ahead and assign these people as the fucking fiduciary to kill any of that fucking presumptory bullshit. You know what I'm saying? Because they're going to pretend to be something unless you put them in their fucking place. And you are the beneficiary, and the source of the whole action to begin with is based on you. So it was all drawn off of your credit and energy and being to even have created the case to fucking begin with. So keep that in mind. Keep that in mind so you can bring a 56F in there and assign them as the fiduciary and order them to fucking go ahead and close that goddamn account. Not in those words, of course. Right? So you, as the living principle on the substantial private side, are speaking on behalf of, but not as, your straw man defendant. Ideally, you have filed before ever going to court your court bond and notice of acceptance, standing, and status, request for remedy wherein you have attached your accepted and return for value documents and your standing status documents that define and clarify your standing as living principle and authorized representative of your juristic person, all caps person, ens legis, or straw man. Right, so all this shit is covered too when you do your UCC 1 and 3 addendum and all that. That's all going to be covered in there. You're going to have all this documentation to be able to slam on their desk along with your invoices and things like that. So by proceeding in this manner, especially when supported by your notary witness documents, you neutralize the presumption that you are attached to and united with your straw man. Right, and so that's another thing too that the UCC 1 does, is that it establishes the separation between your private and your straw man based on the private contracts. So when you end the controversy by your acceptance and return for value, filing the bond and stating that you are not disputing the facts in the charging instrument, by not disputing the facts on the private side, you remove the dispute at its origin and leave nothing to resolve in the public arena. By making your exemption available to discharge, the charges are in harmony with the law, leaving no violation to prosecute. Technically, you could say as a living principle, I do not dispute the facts on the private side, substance side, and my client pleads guilty to the charges on the public side. The point is that if you end the controversy on both the private and the public side, there is no dispute for a court to hear and entertain. There is no one and nothing to prosecute. Then if they wish to convict your straw man of something, let them find the straw man guilty on their own, leaving them exposed. They are welcome to put a piece of paper with the defendant's all caps name on it on the electric chair, throw the switch, and discharge the charges and throw the paper while you are out having dinner with your girlfriend. And so what this is essentially trying to tell you is that you are not your all caps name. They only have the jurisdiction over what they create, and what they create is the birth certificate and the fucking social security card. Give them shits back to them if it's a fucking problem. But don't sit here and pretend that you have any obligations to entertain these people at all when all that they have control over is that fucking piece of paper that looks like your name, but it isn't really. You know what I'm saying? Fucking games. So 22, an interesting property of their equity courts is revealed by remembering the maxim of law that anything outside a box is not there, right? So the four corner rules is gangster, man. I usually always do that, whenever I sign my name, I put a box around the bitch just because. So the witness who gives and so I mean, it symbolizes something else for me too. So it symbolizes Jack in the box, trapped in a box, kind of here on Earth and shit like that. So I kind of put symbols and meanings into the things that I do. And if you know, then you can catch it. If not, then you think it's something else, right? Like a lot of things in this world. So the witness who gives testimony in the witness box. And number 3, the judge who sits on a platform, which is also a box. Only the trustee, defendant, and beneficiary are the relevant in the proceedings. All the rest are parts of the wizard, smoke, and mirrors light show of diversion and misdirection. And they are all boxes like that. And they're set at different planes and things like that too. So you want to make sure that they can even hear you when you're there speaking, and ask if you're on the same plane when you're there. So, because you could literally be in 2 different planets in the same room. So the authors have never heard of this being done, so cannot vouch for the results that this that might accrue from doing so. Since this statement is accurate, explicit, and addresses both sides of the bar, it theoretically should be effective. And I like that. I like that strategy too as well, because when you when you plead not guilty on the private side, but then guilty on the public side, essentially all that's doing is granting them the authority to go ahead and send you the bill if they decide to find your straw man guilty. And it's also creating the separations involved and things like that too between the private and public side as well. It's putting that on the record that you understand the difference, which I think is huge. A lot of people don't get that. So by not traversing into the game and by not trying to defend yourself on your straw man against the charges, you do not enjoin the substantive private common law side with the civil or criminal charges, and thereby become the victim of sentencing as a result. The intent of using the above approach is to truncate the time, effort, and dialogue involved in dealing with giving one's name in court. If you are in this situation and it looks as if it's not getting the job done and getting you closer to what you desire, you can at any time go to the 3 questions approach discussed below. Placing an evidence in court. In the meantime, if you are in court, in a court proceeding, although no one and nothing operating from the public side, all attorneys and government officials can place actual evidence on the record. You, as the real being, especially with a notarial witness, can. People and documents can subpoena for a deposition and evidence in your favor, including the following. In both civil and criminal cases, subpoena persons for depositions and or bringing in documents you require as evidence in the case. These parties can include the mayor of the municipality, as well as the risk management accountant of the municipality, with the document proof that the insurance books are on the case and have been adjusted and a bona fide assessment has been made out of the bond, the original complaint filed with the court, the voucher that must be issued by in the Department of Risk Management of the municipality in which the court is located is to monetize the complaint that creates the funds by utilizing the derivative of the name of the all caps name supported by municipal bonds, right? Since they created it, they essentially own it, and they're gonna have to fund anything that has to do with it. And that goes for anything that you put your all caps name on. So, the car that you buy, essentially, if it's still in their name, the state holds the title. Well, then that's theirs, and you're just the user. So they should be liable for the gas, the maintenance, and even to pay you for driving it, right? Since you're since you're technically considered a state employee by registering your shit, right? Well, that would mean that they're liable for all that shit then, because it's theirs, isn't it? So think about that. So a lot of different things that you could look at here. It's really multifaceted. But the more you know, the better. Knowledge really is power. And it is the game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.